Good morning, everyone. We're going to wait another couple moments to allow everyone to get in from the waiting room.
Oh,
And
Jennifer, we didn't talk, but I think we're going to have time for questions
yes.
following those that were submitted. So if people have additional questions, you can put them in the chat and we'll see what we can do.
Okay, and with that, I will get started with our usual Zoom housekeeping tips. Welcome to the Q&A, everyone. Thank you for joining us today. So if you want to ask a question or ask for clarification, we ask that you put that in the chat. Typically, the mute, unmute, start and stop video buttons and the chat function is at the bottom of your screen, depending on what type of device you're on. So we ask that you stay muted throughout the presentation as much as possible to allow everyone to hear and to reduce background noise. So just a reminder to everyone that the chat is not used for discussion like you see on the CAI message boards. It's to ask for clarification, or as Ken said, we probably will have time for questions at the end. So if you have a question, please feel free to pop it in the chat and we will try to get to as many as possible. This presentation is for general legal information. It is not legal advice. You can only get legal advice from your association attorney who has your documents and knows the facts and circumstances surrounding your association. So anything that you see in the chat, anything that we discuss here in the presentation, any of the videos of the prior Q&As on our YouTube channel, all of that is general legal information. It is not legal advice. If you need specific advice for your association, you need to contact your association attorney. So we're still getting a lot of questions regarding the Corporate Transparency Act, or CTA. CAI National, that's Community Association National, challenged the CTA in federal court. CAI lost the initial court ruling asking for an injunction to prevent the reporting requirements from going into effect for community associations. So all boards should comply with the CTA this year. The deadline for filing is December 31st, 2024. If the act takes effect, or the reporting deadline is actually January 1st. So you should comply before that to ensure that you don't have any possibility of suffering any of the consequences that come with not reporting correctly. So there are a couple bills introduced in both houses of Congress to delay the implementation of the statute against HOAs. So you can try lobbying your state senator and representative. Chelsea has the Chelsea will put the information regarding those bills and specifically where to look for them in the chat. So we think boards can complete the reporting requirements themselves. The process is fairly simple. You can watch our videos the past few weeks, especially I think last week and the week before, and find all sorts of information on the Corporate Transparency Act and and how easy it is to comply. If you already have a login for the federal government, like for TSA PreCheck or Social Security, you're already 90% of the way there to get your individual FinCEN number. So this is fairly simple. We understand management companies are either doing it themselves for a fee or are providing client lists to outside third-party providers who will do the reporting at a fee. You don't have to do that if you don't want to.
But it
So
does require that somebody step up and actually go online to fill out the form. And it does require that board members provide information to the government to get their FinCEN number. I've had to do this. All I had to do, because I was already logged in with my Social Security account as a part of the government system, I had to upload a photograph of my driver's license. So that was the most inconvenient part, was having to take a photograph with my phone, send it from my phone to my email so that I could save it to my computer so that I could upload it to the website. So that was the only thing that took a while. And also, I expect that as we get closer to January 1st, there is going to be a rush of the 80 million people who need to be signed up under this law to use the FinCEN or the government's website. And so I would recommend you don't wait until the last week of December, because I would expect you to have access problems to the government website. Sorry to interrupt, Jennifer.
no worries. So I think we've pretty much covered the CTA. If you have additional questions, we do ask that you check the previous videos. We've been discussing this a lot in the last, especially the last 4 to 6 weeks. So the next topic for just general topics, it's budget season. I know we don't need to remind managers of this, but please make sure you have enough time to get your budgets ratified if you want to increase assessments January 1st. If you do not have a ratified budget with a budget increase by the date that you want to increase the assessments, that increase cannot be collected until the budget is properly ratified. So if you ratify your budget in January, the new amounts become due February 1st. You can't retroactively make them apply January 1st. So please make sure you have enough time to get your budgets ratified and follow proper procedure in order to do that. And then the last topic that we have for just general Zoom housekeeping is the Monday morning minutes. If you're not aware of this, it's put out by Washington State CAI. Chelsea, could you put that link in the chat, please? This is kind of a snapshot of where bills that are of particular interest to community associations. The state CAI will send out a Monday morning minute, just a quick email giving you information on what those bills are, where they are in the legislature, whether or not they're likely to pass, and also gives information on where to send emails to lobby the state legislature for either to pass or not pass. Also, they could send out a request for people to send comments or testify in front of the legislature. So it's an interesting and timely topic to keep on top of things with our state legislature. So, and it's only once a week. We ask that you just kind of take a look at that and just keep being informed. And without further ado, I think we're going to jump into the questions that were submitted this week.
Well,
So the first one, oh, yeah, the first one was.
You already covered number one.
Yeah.
So, okay. So I get the second issue is, the question is, are annual meeting proxies and ballots received for the initial meeting still valid for rescheduled meetings? So this is, of course, going to depend on what the language is of your particular governing documents and the language of the notice in the meeting and the language in the proxy, and if there was a ballot sent in advance, how it's worded. So if what you're talking about is a meeting where you don't get an adequate participation to get a quorum, so you rely on the language in your governing documents that say that the members who do show up are allowed to adjourn the meeting and reschedule it for another date, 3 days, a week, whatever later, and then resume the meeting, then my general rule, without knowing the specifics, would be that if the proxy was good for the meeting to start with, and you have continued the meeting to another date, the proxy is still good. If you had an absentee ballot for the first date and you've continued the meeting, then it's still good. It will depend a lot on whether the process was properly followed in order to continue the meeting. And I'll offer, I rarely see that process followed properly. And it's usually just cleaner and easier to send out a brand new notice and schedule a new meeting so that you know that all of the owners are aware of it. I'm not sure how the people who wrote these provisions expected the members to go out and collect more members without giving another notice to get the participation. But generally proxies are written for either a specific purpose, or they are a general proxy which may extend for months or years. So if it's a general proxy, then it's going to be good anytime the proxy holder shows up with it. The question about ballots gets a little confusing because the new statute, WUCIOA, does allow what they are calling an absentee ballot, that all of the statutes allow for absentee ballots and state that absentee ballots count towards quorum. But the absentee ballots have to be prepared in advance by the association. An owner can't write their own ballot and submit it. An owner can write their own proxy and give it to another person, the board president. They can give their proxy to any other owner. They can give it to a relative. And the proxy can be a directed proxy, meaning it will state explicitly how the proxy holder is to vote on a certain matter. So it is possible for an owner to submit a proxy, assign it to the board, and have it be a directed proxy to vote for or against a specific matter. That proxy cannot be used for any other purpose because it is specific and directed. Whereas a more general proxy saying, I authorize Bob to vote for my unit on any matter at the meeting, that allows Bob to simply vote how he believes is appropriate on behalf of the person who gave him the proxy. So there's a lot of specifics that could matter on this. Our general advice would be that if you have failed to reach a quorum and you need to try again, just sort of start over. If you've sent out ballots in the first place to be used, send them out again. If you are concerned about getting ballots, one of the things you can do is simply have the vote done without a meeting, because the new statute allows for vote by written consent, which does not require a meeting. So you can send out the ballots and you can continue to collect them for as much as 11 months if you need to pass an issue which you're trying to get done. Is there anything you want to add on that, Jennifer?
I don't think so. So our next question, what is the status of email voting on board motions for non-WUCIOA HOAs? What about using an app in our portal to record board votes? So we find this particular question a little problematic because it appears to be circumventing open meetings. HOAs are already required to have open meetings by the HOA statute. So all board votes should be happening in open meetings to allow discussion. Email doesn't allow discussion. The particular language where voting outside of meetings is found is in the nonprofit corporation statutes. That's 2403A or 2406. So any vote outside of a meeting must happen by unanimous written consent and ratified in the next open board meeting. Such votes likely, as we said, violate the open meeting requirements for existing HOAs regardless of when they were formed. So if you are an HOA, PUD, doesn't matter. If you were formed and are subject to 6438, you're required to have open meetings. The ability to have the unanimous written consent outside of meetings goes away under UKIWA. So honestly, it's easier to get into the habit now of compliance and just holding your meetings, or honestly calling extra meetings if you need to for voting. UKIWA allows unanimous consent for ministerial acts. What ministerial is has not been defined by the legislature, and of course there hasn't been case law yet, but we recommend not being the test case for this. A web portal to track voting by board members does nothing to solve the problem of open meetings, and it doesn't reduce the requirement for unanimous consent from every board member. It also doesn't ratify that particular decision in board meeting minutes. So we don't believe that just voting in a portal is enough by itself. A web portal may also not meet the requirement that unanimous consent be in writing. So this practice is problematic on several different levels, especially since UKIWA is becoming effective in 3 years. So honestly, it's easier to just get in the habit now of calling more meetings and doing your voting properly so you rush or have problems once UKIWA is effective. Ken, did you have anything to add to that?
Well, I'll just offer that there's a lot of debate right now in, I'll say, amongst the lawyers and people trying to work with the Legislative Action Committee about how much of an impact the requirements in UKIWA for open meetings and prohibiting discussion outside of meetings and prohibiting email decisions, how much of an impact that is going to have on management companies and boards in how they operate their communities. And there's a group of people on one side who are convinced that this is completely unnecessary and unfounded, and there's another group, and I would say I fall closer to this group, which are saying that this shouldn't be that big a deal if you can just plan a little bit better how you are conducting the business in your community. But the reality is, it is going to be more difficult to comply strictly, and it's going to provide a lot more ammunition for owners who want to challenge what boards have done to successfully challenge. There's no question that the legislature has a belief that there are homeowner association and condo association boards who are acting in secret and doing things which their membership doesn't know about. I don't know why the legislature thinks that, but the legislature has clearly embraced the idea that all meetings should be open and that every member of a community should be entitled to know what's going on if they ask. And so, I guess my position is it's not unreasonable what the legislature has mandated. And so if you are intentionally going against the spirit of that legislation, then you are going to be at risk if someone starts challenging the decisions you make. Now, there's no question that we have, I would say probably a majority of our clients where they conduct the business of their community. No one in the community cares about how they're doing it. The community may approve of what the board's doing. Everything goes fine. There are violations of the current statutes regularly and routinely, and they just don't matter. And so it's likely that just as A lot of communities are failing to hold open meetings today, which they're required to do. And that doesn't matter because no one's challenging it. That you'll get under UKIOA and no one will challenge the decisions and how the process is being handled then. But we do recommend that you follow and comply, just like I recommend if the speed limit on the road is 60 miles an hour, you drive under the speed limit. So I don't know if you got anything else you want to add, Jennifer.
I think we've covered that.
All right. So next question. For a budget ratification, upon receiving the budget mailer, if the homeowner let the manager know that they rejected the budget, do we count this? Can other homeowners bring proxy with them and vote no for the proposed budget on behalf of all the proxies they have brought? So the short answer, again, this isn't legal advice, is that just an email or a phone call from an owner saying they vote to reject the budget is not going to be sufficient to qualify as a no vote on the budget. They can certainly give their proxy to someone and that proxy can vote for them. If they were to, as we sort of discussed before, if they were to assign a directed proxy to the board for their no vote, they could probably make that work. But you can't just rely on decisions outside of the meeting, because one of the premises is that you have the budget ratification meeting and you discuss the budget, and that you cannot make a fully informed decision until that discussion has taken place. So it could be a person would say that they reject the budget before the meeting, but if they had gone to the meeting and listened to the presentation, they would have been okay with it. And so by the same token, they can't approve the budget in advance of the meeting either. The language of the proxy would state what authority the proxy holder has in voting on behalf of the owner. And the other thing I'll add is that in most cases, that vote to reject the budget isn't going to matter because it is such an unusual circumstance to get enough votes for the vote to reject a budget to achieve the 50% of all owners required. And then the last caveat I'll offer is that it is possible for CC&Rs or condo declarations to be written to prohibit proxy voting. And also they can be written to prohibit mail-in or absentee ballots. It's very unusual for that to occur, but it is possible for it to be written that way. Anything you want to add, Jennifer?
I think we covered it. So the next question is, do the reserve account withdrawals noted in 6434-384 require a vote of the owners? And this language is standard across the common interest community statutes. So what this particular statute states is that when the board decides to do a withdrawal out of reserves for non-reserve expenditures, formal notice has to be sent to the owners regarding that expense, along with a repayment plan to fully repay the amount taken out within 24 months, unless that particular amount is unreasonable to be paid back in that amount of time. So the answer to the question is no. Withdrawals from the reserve do not require owner approval. However, owners must receive notice. So formal notice must be sent, but owners don't vote on it. Ken, did you have anything to add?
Not on that. I did have a community this last week where the owners wanted to, or believed, some of the owners at a meeting believed that they had to vote for a reserve expenditure for the building. And there is no requirement for owners to vote. That's a board decision. If they are not required to do a special assessment, the board can spend the reserve funds on a reserve project without a vote of the owners. And that doesn't mean you shouldn't inform the owners, which is what was going on at the meeting I was at. But the board is elected to make decisions on behalf of the association, and deciding how to maintain the building is part of that authority the board has.
We had a request for a little clarification in the chat. Can you include a capital improvement expense in a budget? So do you mind if I take a quick stab at this, Ken?
Sure, go ahead.
Okay. It depends on the language in your documents. Capital expenditures typically have a voting requirement that owners must vote by a certain percentage approval for, I'm usually seeing about $5,000, not adjusted for inflation. You can include it if the owners ratify the budget, then it's probable that you could include it in the, you can make that capital improvement. That procedure could be subject to challenge, but it really depends on your governing documents.
Well, my answer would be that if the capital improvement requires the affirmative vote of the membership, that having a budget ratified without the affirmative approval of the necessary percentage is not going to be the same as approving a capital improvement. So there are two kinds of votes that are very different, and I would not say that you could use the ratification process to make a capital improvement authorized. You could certainly have a separate vote on it at the meeting. It's also possible that the capital improvement text of the document could be written to allow for the capital improvement included in the budget and ratified by the owners to be installed, but that's a different percentage or voting requirement. Right. Is it my turn?
Yes.
Yeah. In the absence of a pressing issue in the community, would you generally advise that a condo association delay updating older governing documents until 2028 when UKIOA will apply? Or would it be beneficial to have an attorney review the documents now and identify which sections are superseded by UKIOA and which remain valid? So I don't see a problem with delaying. And there may be no reason to amend your documents at all, but you do have to comply with the new statutes. And so I think that it's probably valuable to have your documents reviewed by an attorney so that they can tell you what sections have been either already wiped out because the statutes have been amended multiple times since they took effect, or what sections will be modified when UKIOA takes effect. And you can then decide whether you want to just keep that list and follow the statutes, or you want to amend the document so that they would reflect in one place those new requirements. So it's also going to depend a lot on the age of your documents and what amendments you've made over time already. Documents prepared under the Condominium Act are far more likely to match closely sections of UKIOA. Documents prepared 40 or 50 years ago before the HOA Act took effect are unlikely to have anything that addresses most of what's in UKIOA. Okay. So there's some things which are allowed under UKIOA, which a lot of people think somehow are automatic, and that's not the case. So if you're looking for something like the ability to shift deductibles to individual owners, you need an amendment to the language, whether you're under your existing condominium statute or whether you're under UKIOA. And there are some things that are little details that you may have to worry about. Like if you have an insurance shifting amendment today, it may not be fully consistent with UKIOA. So for example, under UKIOA, for negligent act by an owner, you cannot assess more than the amount of the deductible under the HOA policy. And you're required to give a notice and opportunity to be heard before you can assess anything to them. And if the owner was not negligent, you can't make an assessment to them for negligence anyway. So we have a lot of clients with amendments that were written dated back into 1990 by Jim Strickerts, which have strict liability. If the hot water tank in your unit fails, you have to pay for all the damage that it causes. And a lot of people think that's fair, but unless you can prove the hot water tank owner was negligent under UKIOA, you cannot assess the cost for all the units to the water heater owner. You can assess the cost in that owner's unit, but your downstairs neighbors would have to take care of the deductible within their own units in most cases. So if there are, if your documents are not written under UKIOA, then I'd certainly recommend figuring out what is different between UKIOA and your documents so that you can comply with the statute. Sometimes it's easy to update things like the bylaws so that you're taking care of the open meeting requirements. And, you might want to include provisions for removing a delinquent board member, which come with UKIOA. But you don't need to actually amend the documents. So, Jennifer, more to add?
No, I think we've covered that. So the next question is, if there's a conflict between our nonprofit statute and our common interest community statute, for example, when it comes to records, which one controls? So the two of the common interest community statutes actually have language regarding this, and it is 6490 400 sub 4. And that language states, in case of any conflict between Title 23B or Chapter 2386, 2403A, 2406, or 2515, and this chapter, meaning 6490, this chapter 6490 controls. Also in the Condominium Act, 6434-300, and pretty much same language. In case of any conflict between any of the corporation acts and 6434 controls. So the general proposition is that the more specific statute controls, but in this particular instance, the legislature put into the statute itself that if there is a conflict between the nonprofit corporation statute or any of the corporate statutes and the common interest community statute, the common interest community statute does control. Ken, did you have anything to add?
Well, I would just add that even though the HOA Act did not have that same specific language included, that I think a court would apply the same rule and say that the HOA Act's record requirement is going to control. So, next question. I know an association may not foreclose on a home for fines only, but can a lien be placed on a unit for a fine? And would that require it be paid off if the unit sells? So the short answer would be yes, you can record a lien for any valid unpaid balance due. So that would include fines, late fees, interest, and unpaid dues. And you can record a lien even if you cannot foreclose on the home for that lien. Okay. All of the statutes were changed in 2021 to provide additional protection to homeowners because of the pandemic. And you have to meet those specific requirements, which include, dollar amounts for unpaid assessments, etc. But that does not affect the other collections efforts that a board can take against a delinquent owner. And the delinquencies could include late fees, interest, and fines. So you still have options of taking an owner to small claims court. You still have options of suing for a personal debt to be paid, meaning, instead of foreclosing on the property, you are suing the person. Okay. Another thing to remember, though, is that recording a lien does not affect a statute of limitations. So if you only have 3 years to collect on an assessment under the Condominium Act, and you record a lien, it becomes uncollectible after 3 years if it's not been paid. So putting a lien on a property that the owner doesn't sell may not be an effective means of collections. But most of the time when a property does sell, all liens are going to be paid. Not necessarily because the owner is required to pay it, but because the banks involved are going to make sure that the liens are gone, and the buyers involved are going to make sure that all the liens are gone. So if you're concerned about statute of limitations issues on liens you placed, you do need to pay attention, and you need to file a lawsuit of some type in order to stop the statute of limitations from running. Okay. And I would say that if you've got issues involving unpaid fines, unpaid late fees and interest, you may want to talk to an association attorney to determine what of those are worth trying to collect. And it's certainly possible that an attorney will tell you that the amount of money you're looking to seek, or the reason you're trying to seek it, doesn't justify the risk and expense and irritation of hiring a lawyer to pursue that for you. Jennifer, anything to add?
Just generally, Valerie helped answer this question. She generally deals with collections. She did point out that we generally recommend having an attorney prepare the liens, because too often we see defects in liens that have been recorded by lay people. So in order to preserve your right to collect unpaid amounts due, please contact your association attorney. They can give you guidance on statute of limitations issues, as well as just, is this particular amount collectible? Courts disfavor fines, and fines are treated as more of a compliance, trying to get compliance rather than a income stream to the association. So it really depends on the amount of fines, what the fines are for, etc. There are too many specifics. There's too much specific information we would need to give a concrete answer for any particular issue. Ken, did you want to add anything more to that, or should we just move on?
Let's move on.
Okay. So the next question is there any statute that legally requires management companies to send account statements reflecting balances in the mail versus email? So just in general, I know a lot of the individuals on the Q&A are managers, but we don't give legal advice to management companies because you're not our clients. The associations are our clients. So what a manager is required to do is different than what the association is required to do. What the management company or manager is required to do is reflected in the contract they have with the particular association. So generally, managers are assuming the duties of the association. So if the association is required to mail something, then the management company is required to mail it to them. Ken and I had different takes on this particular question. So in general, notice to owners is provided for in statute, and that's 6432-270, 6434-396, 6438-110, and 6490-515. So under these particular statutes, if owners have not opted into receiving electronic notice or notices via email, then email does not count as notice. So if there is something that you are required to send by the governing documents or statute, and the owner has not opted into receiving electronic notices, it must be sent through the mail. But if owners aren't delinquent, this probably isn't an issue, and you can just, if you're just sending notices, not notices, I'm sorry. If you're just sending an email to owners with their current balance showing that their payments have been applied and there's no delinquency, you can send that via email. It's not required under statute. It's probably a courtesy. But if owners are delinquent, there are particular statutes that apply to how delinquent owners are notified, what information must be sent to delinquent owners. So you really need to follow the statutes for that. And then again, mail is the gold standard when it comes to notice. It is the main way provided for in the statutes. If you don't follow the statutory requirements for notice to delinquent owners, then collections may be delayed to fix those particular deficiencies in the procedure. So Penn noted that he's not aware of any statutory requirement to send statements like a bank might on a monthly basis. If an owner asks for a balance, then you can probably provide it by email. If they mail the request, then mailing the statement back to them is probably the better way to go. Ken, did you have anything to add to that?
No, well, I will offer that I understand a lot of the management companies have web portals where owners can go to look up what their account balance is. And that's as a courtesy to owners so they can check if their payments have been applied. I don't know if there are management companies which routinely send out an email to every owner on a monthly basis so that the owners know that they've been applied. If the question is about that kind of a courtesy notice, I think that email is just fine because I don't know of any obligation to actually send out a notice that a payment's been received. So if there was something special in the governing documents that required that owners be given notice of a payment being received or notice of their statement balance, then you would have to follow the same statutory requirements for notice. But otherwise, I think you covered everything. And with that, we've run out of our prepared questions. And so if people have any in the chat, we could cover those. Do you see any, Chelsea?
We have quite a few. All right, so first, an HOA has a resident who has exhibited behavior dementia. She has also expressed suicidal thoughts to several neighbors. Her behavior has become disruptive to other residents. The board would like to know at what point can they reach out to the emergency contact for the resident. The person lives alone and has no next of kin, so the emergency contact is her lawyer. The same HOA has a resident, not an owner, but a tenant. He has allowed persons to sleep in the garage and has made others in the building feel unsafe. Am I correct that there is little the HOA can do to evict a person, given there is no lease in place? This person simply lives with the owner.
Well, this is starting to sound a whole lot like specific questions that need legal advice, which we can't offer. But I would say generally, boards or managers can use their judgment to decide when to contact an emergency person when they are concerned about a resident. And so, given the way that was worded, I would say it seems reasonable to contact the emergency person and express the concerns which the community has, even if the emergency person is an attorney. I have had cases before where the only additional contact we had was a lawyer, and the lawyer did know where other family members were, and the lawyer was willing to help us in solving problems with an owner who had a trust that owned the unit, and the owner had behavior issues. So I don't see a reason to hesitate in looking for additional resources when you're concerned about the resident. As to owner or people sleeping in garages, there's a whole lot of information I'd want to know, and what kind of community, what kind of garage. One of the things I did find interesting in the last legislative session was that the legislature put a new law in place that you cannot enforce any kinds of restrictions on unrelated persons residing in a unit. So I don't know if the person sleeping in the garage qualifies as an unrelated person living in the unit, which would probably limit what you could do. And I don't know if there are other sections of the declaration which might apply. So we certainly do have some clients where the declarations are specific that a garage cannot be used as part of the dwelling, and that would, at least in theory, provide a basis for enforcing keeping an owner from sleeping in a garage. Any thoughts, Jennifer?
Just briefly, when it comes to older individuals living by themselves, anyone can make a report to Adult Protective Services. That's a way to start notice to governmental agencies regarding this person. They don't have to take help offered, but it's at least a way to start seeing if services are available for this particular individual. So reaching out to family members, reaching out to contacts that the association has is a good way to go. You can also reach out to Adult Protective Services who may start looking into the situation. If an individual, it doesn't matter who they are a danger to themselves or others, call the police.
Yes, because the police will come out and do an evaluation themselves. And if the police find that the person is at risk of suicide, for example, they can do a three-day hold for the person in the healthcare system so the person can be evaluated. So, next question, Chelsea.
All right, so next, unit has cockroaches. Now they have expanded in other units. Because owners are responsible for their units, the board advised all owners to coordinate together to have pest control come. Some owners are not responding. What should the board do?
I'm going to offer that that is too specific for us to answer. There is certainly I'll say a conflict between saying that each owner has to take care of bugs in their own unit, but then it not being possible to effectively do that without the coordination of all the owners. So we have certainly advised clients before when they had issues with bed bugs or cockroaches that it could be an appropriate common expense, and the association could use the entry provisions which are provided in their declarations to gain access to the units following notice to the owners. So it's going to require more investigation and knowing what the documents provide and what kind of community in order to give advice. Your thoughts, Jennifer?
Contact the association attorney. They can help walk you through this particular situation. It's one that we've dealt with many times. Next question.
All right. Do homeowners have 6 months to oppose anything the board has done in a meeting?
Well, I'll offer no. I don't know where that would come from. Under WUCIOA, there is a specific provision that an owner cannot challenge a board's decision following 90 days of the decision being told to the owners. So that's not a timeline following the board meeting, but it's a timeline following when the owners are given notice of a board decision. So if the board's adopted a no smoking rule on June 1st, and then they never sent out notice to people about the no smoking rule, the 90 days would never start. But if on July 1 they sent notice out, then there would be 90 days for an owner to challenge it based on, the process or, how the board made the decision. And it's an interesting provision that WUCIOA has provided. And I think it's specifically to try and avoid people going back through old meeting minutes and finding a procedural error from 2 years earlier and trying to reverse a board decision based on that. Jennifer, your thoughts?
Notice doesn't have to be formal notice sent in a letter. It can just be board meeting minutes posted for owners to view. So how that particular decision is informed to the association matters. If it's just contained in board meeting minutes and that's where it's supposed to be, then that would be the notice to the owners to start the 90-day process. But
Yeah,
it's approved board meeting minutes. Sorry, Ken.
I think it also is going to depend on what kind of board decision it was. If it was a board decision to enter into a contract, then
So I'm going to go grocery store.
yeah, if it's a board decision to enter into a contract, I don't think you're going to be able to challenge it 90 days later either, because it's already been in effect and a third party is relying on it. So it starts to get very specific, and it depends on whether or not also the decision is in conflict with the CC&Rs or bylaws, or because the board's not allowed or authorized to make a decision that is not within their power under the governing documents or statute. So, anyway, any new one, Chelsea?
Yes. Clarification again regarding grilling/open flame cooking on decks in Seattle. It seems that the purpose of the emergency order WAC 24-07-059 was to make it clear that the restrictions on open flame cooking devices are not included in the state's building codes. The board is still unsure/questioning if Seattle is more restrictive, which would be to not allow open flame within 10 feet of a structure, which is contrary to what we have been talking about in 2024. And just sending.
I am not familiar enough with the code to answer that question today.
It seems to be too specific for this particular forum. Please ask your association attorney.
All right. Is there anywhere that we could get a copy of our governing documents? We have copies of copies, which make the document difficult to read.
Ken, do you want me to start
Go
this? Declarations are typically actually have to be recorded with the county where your particular association is. Depending on the age of the documents, you can go to the county with the copy that you have, if it has a recording number, and pull what they have in their possession. Sometimes the microfiche is hard to read as well. It really depends on the age of the document. You can also go back to your particular title report isn't what I'm looking. Well, title can pull. If you have title insurance, title can pull whatever documents are contained in public record, which is with the county. Your resale certificate should have, well, it may be the copy of the copy, but typically at least the declaration is with the county where the association is located. Articles of incorporation, maybe bylaws. We don't often see them there, but it could be there, could be with the Secretary of State. That's rules and regulations are just with the association. Bylaws may not have been recorded, so you may be stuck, but you can always follow your procedures and get the owners to vote to approve new bylaws that are more legible. Ken, did you have anything to add?
No, I think you covered it. The Secretary of State may have articles of incorporation. The county recorder must have the CC&Rs or condo declaration, and they may have bylaws, because even though bylaws need not be recorded, many times they are. That doesn't make them more legible, and it is certainly possible for you to retype the documents and make them completely legible, and you can have them re-recorded You may require a vote of the owners to confirm that the language of the new document is correct. But we do have clients who will take their fuzzy documents with 13 or 15 or however many amendments, have them retyped into a single new legible document, removing all of the conflicts between the different amendments, and then vote to have their owner or by their owners to simply re-record it. So we had one last year, I think 33 different amendments, a lot of parking space swapping and storage space assignments and phase amendments by the developer. And they were able to cut their stack of paper for the resale certificate from over 600 pages to down to under 100. You have a new question, Chelsea?
Can the board increase fine amount if the violation involves endangerment to others, such as gunshot and property damage?
Well, is that a question? They can, whether or not they can do that? So if their fine schedule is explicit that certain kinds of violations have higher fines associated with them, it's probably okay. But you do have to remember that you can't assess a fine until after you have given notice and an opportunity to be heard. That's not the same as giving a warning. It's just you cannot assess the fine before you give them an opportunity to be heard. If they request a hearing, you have to have the hearing. You cannot assess a fine and then tell them they have the right to appeal in order to comply with the statutes. Jennifer?
I would also add that any fine must be reasonable, both when it was first imposed and in total, and part of a schedule previously published to the owners. So this language is in 6434-304 sub 1 sub K, 6438-020 sub 11, I think, and I can't remember 6490 off the top of my head. So this particular language applies to all community associations in Washington state. Fines must be reasonable, part of a schedule previously published to the owners, and levied after notice and opportunity to be heard. So if the board wants to increase the fine amount for, say, clear and present danger to other owners or violations of law, they can do that as long as owners receive that heightened fine amount before it's tried to be enforced. And then once the fine is levied, it's after notice and opportunity to be heard.
You guys ready for another one? Or,
Sure.
Okay. We have always had our budget ratification and annual meetings together in October. It's getting too stressful and we are considering separating them. Is this typical? And if so, when are annual meetings generally held?
Well, I'll take a stab first. It's certainly common for associations to have separate annual meetings and budget ratification meetings. Some governing documents require that the annual meeting be held in the first quarter or when the financials have been completed for the year. So you need to look at what your governing documents state for as part of this query. But we have a lot of communities which will hold their elections and have the annual meeting in the spring or in the first quarter of the year, and then they will do the ratification later. This is in part because many communities didn't have to ratify their budgets until 2018 came along. And so they started ratifying their budgets in November or December because they wanted their assessments to change January 1st. And they continued to have their annual meetings whenever they had done it before. Any thoughts, Jennifer?
I think you pretty much covered it. It's just whatever's in your governing documents, you have to comply with that. It's common to separate out the budget ratification meeting and annual meeting, typically because budget ratification doesn't require quorum, but an annual meeting and election does. And I think we're at 11.
Right. Well, then we'll see everyone next week. I think there was a question in the chat about whether we're having a Q&A the week of Thanksgiving, and the answer is no, we are not. So, all right. Goodbye,
Thanks,
everyone.
everyone.